We believe October 24th is the day he died. But under State versus McDonald, 144 Wis 2nd, 531, I believe a defendant's right to final determination of the merits of the case survives his death, meaning that an appeal that was timely filed and begun continues at the discretion, I guess, of the estate of the deceased, even though the defendant has died. So I believe that's the situation we were in. Mr. Pierce, before he died, shortly before he died actually, his attorney filed a motion for post-conviction relief. That was filed on August 20th of 2024. I then issued a briefing schedule asking the state to respond. The state did so on November 1st, and then there was a reply brief filed on November 15th of 2024. I have reviewed those briefs in detail, and I'm prepared to render a ruling on them. I don't know, Mr. Peters, whether you wanted to say anything in addition to the briefs that were submitted. I will give you that opportunity now. I would just urge you not to reiterate what's in your brief because I've reviewed that already. So go ahead.
Judge, I didn't plan on making any further statements in the brief.
Ms.
In
Nordine.
reply.
Thank you. Ms. Nordine?
I have nothing further to add, Judge.
All right. So this is a post-conviction motion under 80930, and there's really a couple of arguments that are being made here. And first, the first set of arguments revolve around, I think, evidence that the decedent now claims that I wrongly admitted into evidence. The first is Carol Pierce's statement to Mary Ann LaViolet that Mr. Pierce would kill her one day. This is something that came up in the evidence that was discussed at length outside the presence of the jury. It was addressed at length in pretrial motions. And I ultimately ruled that that statement was admissible, that it showed Mrs. Pierce's then existing emotional or physical condition, which is a hearsay exception. It's 908.03 sub 3. And I ruled at the time that this was a hearsay exception. And I looked at this and I see no reason to change my opinion of it. I think under the authorities of the state of Wisconsin, and certainly Daniel Blanca, who I consulted in terms of his reference book, this is a classic example. At that point in time, she was fearful. That was the evidence, that was the, I guess, idea behind it, that she was fearful, and I felt that this was circumstantial evidence of her state of mind. It was not being offered to prove, that Mr. Pierce acted prior to that time in any way, or that he would act necessarily this way in the future. But that Carol was fearful. I should note that at that particular time that this evidence was evidence that the defense wanted as well, because it fit in with the narrative that Carol Pierce might have been fearful and might have absconded. And that I felt that this evidence was probative, that the prejudicial effect of the of the evidence did not outweigh its probative value for both the defense and the prosecution. I felt that the defense could have used this and did use this just as much as the prosecution. And I think that it fits squarely within that exception. And I see no reason to change my opinion about that. And so I'm respectfully denying the defense's motion on that particular statement. Then there was this incident that occurred. This was a very central incident, I think, in the case, that Roy Carney, who was a person that was involved in this case, a character that was involved in this case. He didn't testify at trial. I don't believe he's alive anymore. But there was some evidence that Mr. Carney had some sort of romantic involvement, possibly, with Carol Pierce. And we don't know that, and certainly the prosecution didn't try to prove that. But there was a statement from Kent Kramer. And these people were Coast Guard workers. They were members of the Coast Guard. But they were on a vessel here in Sturgeon Bay when Kent Kramer, I believe it was in Sturgeon Bay, but they were on a vessel. Kent Kramer and Roy Carney were discussing Carol Pierce, and Roy Carney allegedly said that Carol Pierce was quote-unquote hitting on him, Roy Carney, meaning making some sort of romantic advances to him. And they thought that Mr. Pierce was not around, but when they looked up, they saw that Mr. Pierce was indeed just in the other room and had a very stone-faced look on his face. He was obviously quite taken by this statement that I think the description was that he had a stone face, and that was all. And I guess that could mean a lot of different things, that he was angry, that he was concerned. And there was an objection at the time of trial by defense counsel to this on the grounds of hearsay. But again, this was not being offered to prove that Mr. Carney was having an affair with Miss Pierce, or that Miss Pierce was actually making romantic advances to Mr. Carney. The object of it is to show the effect on Mr. Pierce, that Mr. Pierce thought that this was happening. It could have been anything. It could have been that Mrs. Pierce was, to use a ridiculous example, dancing in her underwear or something like that, or doing whatever that upset Mr. Pierce. And so the testimony wasn't being given to prove the truth of the matter, and in fact, there was never any proof in this case that such an affair existed. There were no other witnesses that tried to corroborate that they were having an affair. I'm talking about Mr. Carney and Mrs. Pierce now. That was just never a line of proof that the prosecution ever pursued. But what they did pursue is that Mr. Pierce perceived that there was some sort of relationship, I guess, or at least some sort of something going on that irritated him, because otherwise why would he have a stone face? Hearsay, an otherwise hearsay statement that's not being given to prove the truth of the matter is by definition not hearsay. And that's what I ruled. And as I look at this, I have no reason to change my ruling. I don't think it was being offered to prove the truth of the matter. And the argument is here also that when Mr. Grody, who prosecuted this case, went to his closing argument, he violated that and basically said that there was an affair. But when I look at what Mr. Grody said, I don't believe that's what he said. He said that Carol Jean thinks that the defendant is going to kill her. We know that there's he says we know there's violence in the Pierce marriage. Mary LaViolette tells us this. Carol Jean thinks that the defendant is going to kill her. I think there's nothing wrong with saying that Carol Jean thinks that the defendant is going to kill her because that's what she said. That was her state of mind back then. In terms of violence, there was other evidence of violence. There was evidence that she had bruises on her face. There was evidence. There was other evidence of violence. So, but when Mr. Grody says Carol Jean thinks that the defendant is going to kill her, I don't think he says anything there that wasn't part of the evidence. That's exactly what she said, and that doesn't mean that he would kill her or that he did kill her. It just means that she was fearful that he would. And then he says, we know that Mr. Pierce overheard this discussion between Kent Kramer and Carney that Carol Jean had been hitting on Carney. And if there's violence in a relationship, and again, he doesn't say anything more than that. He doesn't say, and we've proved that Mr. Carney had a relationship with Carol Jean Pierce. He doesn't say that. That would have been objectionable. But he says, we know that Mr. Pierce overheard this discussion. And then he goes on to say, I think it's fair to conclude that Mr. Pierce responded to that with violence. That's his argument. That's his argument from the evidence that's been admitted into evidence. That's what you do in argument. You take logical inferences from evidence and you make an argument. And the defense was free to stand up and say, no. That's not a fair, conclusion. This is the conclusion that we should make, and argue something else from the evidence. I don't think there's anything about what Mr. Grody said there that is unfair or is not a logical extension or inference from admitted evidence. And I believe my rulings on all of those evidentiary matters, which were extensively argued, I should say. These aren't things that just came up. They were extensively argued beforehand and again at the time of the trial. And I made my rulings, and I don't think there's anything wrong with my rulings. So I will just say that I will deny the defense's motion based on sub-Roman numeral 1 of their argument. Sub-Roman numeral 2 argues that Mr. Pierce is entitled to a new trial in the interests of justice. And I don't know, quite frankly, I don't necessarily understand this. Basically, the argument is that on the totality of the circumstances, that the controversy wasn't really tried. The actual controversy wasn't really tried. Some other controversy was tried. There's a reference to this testimony about the rake, and Mr. Heimerl's testimony concerning the rake. And I went back and I looked at that, and the prosecution's dog handler did testify that the dog indicated on a cart, a tool cart, and it had various tools on it. It had hose endings on it. It had various tools, and one of those tools was a rake. But nothing in that record suggested that from the dog handler that it alerted on the rake necessarily. And then Mr. Heimerl, who's an investigator, came along and simply laid a foundation for a bunch of photographs that he took. And a couple of those photographs was of the tool cart and of the rake. And Mr. Heimerl did not testify that the dog hit on the rake. He simply stated that this is where the rake was, this is how it looked, and he took various photographs of the rake, but he was simply laying a foundation for the photographs that he took. Now, Ms. Seidmulder, the defense counsel, wanted her investigator to talk about a 2008 investigation that took place with a dog. I never saw that investigation. Apparently, a dog was sent out in 2008, and it came to there were different conclusions about it. And she didn't have the dog operator testify from the 2008 investigation. She simply wanted her investigator to testify about what the 2008 report said. And Mr. Grody objected to that. He said, there's no foundation for this. This is hearsay. This is somebody else's report. I can't cross-examine that witness. And this witness can only just regurgitate what's in the report. And I ultimately sustained that objection. And the argument here in this brief is that somehow this, along with my other erroneous rulings on the evidence that I've just addressed, combine to make it unfair that Mr. Pierce be convicted, that the real issues were not tried. And I just simply, I simply disagree with that, and I reject that argument. I believe we tried this case for 6 to 9 days. I don't remember which. They were long days. They were hard fought. I thought both counsel did very well. We had every issue tried. The case was postponed a number of times. Everybody had the discovery. And when I say it was postponed a couple of times, I simply mean there was plenty of time to go through the materials in the file. And I believe all of the arguments were made. Could some of them been more forcefully made? I don't know, but that's not a question of, overturning this conviction that 12 people came to, that this verdict that 12 people came to. And I see no good reason to overturn my rulings in this case. I think they were sound. I hope they were. I respect the fact that somebody's questioning them. They have the right to do that. But I respectfully deny the motion for post-conviction relief. All right. Ms. DePeters, anything else?
Just to clarify, and I think it's apparent what you said, but I just want to clarify it. During the trial, when you were making these rulings, you consulted with Linka's book, not Linka himself.
That's correct.
And then I realized that, but the way you said it was just a little unclear. And then the state, and I understand what the court's saying about this, but I also just want to clarify that in terms of the statement from La Foliette, the defense attorney did object to that admission. It might have been useful in your view in the end to them, but they did actually object to that admission.
I appreciate that correction. I couldn't remember exactly, but nevertheless, I stand by my ruling.
And I'm not saying it would change your ruling. I just wanted to make sure that was clear for the record. All right, Judge, what I'll do now is I'll just go ahead and submit a written order that'll be very brief, just based on the hearing today. you're denying the motion, and I'll
Thank you.
submit that for you to sign.
Thank you. And I believe the record should reflect that Mark Clark has joined as well. He's also a relative of Mrs. Pierce. And by Zoom. Ms. Nordine, anything else?
Not that I can think of, Judge, thank you.
Any other findings you'd like me to make?
No, not that I can think of. I think you addressed each of the issues that was brought forward in the original motion for post-conviction relief. You addressed each of them individually and denied each of the arguments. So I think, and then the motion in itself, you've also denied. So I think that everything has been done today that needs to be done.
Okay, have a good day. We're in recess.
Thank you.
Thank you. Thank you. Thank you.
Yeah.